Dear friends, today I will discuss Rules 7 and 8 from the Patents Rules 2003 as amended by Amendment Rules 2016. Right? So you can refer to other amendments as well if any updations has been made or not. Fine. Okay. So let us start. Rule 7 has the title fees. That means in Rule 7 we will discuss about fees. Okay. So sub rule 1 says the fees payable under section 142 in respect of the grant of patents and applications thereof and in respect of other matters for which fees are required to be payable under the act shall be as specified in the first schedule. So please take a look at the bold letters. That means here these are the keywords, and these keywords are, for example, under section 142. That means we need to know about section 142, and we know it very well that the title of section 142 of the Indian Patents Act is fees. Okay, so we can say the related section and rule are section 142 and rule 7. Fine. So here the fees, so I will read it again for for an easier understanding. Just take a look. The fees payable under section 142 in respect of the fees in respect of what? The grant of patents and applications, and also for other matters for which fees are required to be payable under this act. Okay, so all these things are specified in the first schedule. Fine. Also, some conditions are there, provided that 10% additional fees shall be payable when the applications for patent and other documents are filed through physical mode, namely in hard copy format. Here also please take a deep look into the underlined words. That means there will be 10% of additional fee for the files that are to be filed through physical mode or that is hard copy format. Fine. Also provided further that in the case of a small entity, that means if we can say if a small entity is it deals with that means we can say that either a startup or a small entity or an individual person, like these things, these are the entities. Okay, that means which can apply for the patent or grant for the patent, but here we are just talking about a small entity. That's why I have underlined here about the small entity. So provided further that in case of a small entity, that means if the applicant is the small entity, every document for which a fee has been specified shall be accompanied by Form 28. That means for a small entity, each and every document for which fee is to be applied or specified, all these are accompanied in Form 28. And what is Form 28? Form 28 has the title to be submitted by a small entity or startup. Okay. So here Form 28 deals with small entity and startup, and in Rule 7 we have mentioned for small entity only. Fine. So next we will go to Sub Rule 2. Sub Rule 2 Clause A says the fees payable under the Act or these rules may be paid at the appropriate office either in cash or through electronic means, or may be sent by bank draft or banker's check payable to the controller of patents and drawn on a scheduled bank at the place where the appropriate office is situated, and if the draft or banker's check is sent by post, the fees shall be deemed to have been paid on the date on which the draft or banker's check has actually reached the controller. So these are the some conditions. Just observe the bold letters. That means appropriate office, cash, electronic means, bank draft, banker's check to the controller of patents, drawn on a scheduled bank, by post, paid on the date, actually reach the controller. So these are the keywords. So what is written here, that the fees payable under this act, this should be paid at the appropriate office. And by what means? They can be paid in form of cash or electronic means, that means online as well. Okay, or may be sent by a bank draft or a check, banker's check. And all these are payable to the controller. Just recall friends, whenever we do a demand draft, what we are writing there? We are writing there to the some portion, payable at, and in favor of. These three things we are writing. Here also this payable to is the controller of patents, okay, and drawn on or in favor of or drawn on a scheduled bank at the place where the appropriate office is situated. And if the draft or banker's check is sent by post, that means the bank draft or the banker's check is not given in hand and it is sent by post, then the fees shall be deemed to have been paid on the date on which the draft or banker's check has actually reached the controller. That means the date on which the controller receives it, that date only is calculated. Fine. Then what is about clause B? Clause B was omitted with effective from 16th May 2016. That means through the amendment rules of 2016. Fine. Then clause C says, where a fee is payable in respect of a document, the entire fee shall accompany the document. Okay. So it is quite clear that whenever a fee is payable for a document, the entire fee shall accompany the document. Fine. Okay. Next one. Subrule 3. In case an application processed by a natural person is fully or partly transferred to a person other than a natural person, the difference, if any, in the scale of fee or fees between the fee or fees charged from a natural person and the fee or fees chargeable from the person other than the natural person in the same matter shall be paid by the new applicant with the request for transfer. That means we are discussing about a condition where transfer has occurred. Okay, so what happens here? See, in case an application processed by a natural person, first of all, a natural person has processed an application. Okay, and we or that person wants to fully or partially transfer that application to another person. Okay, so there is a difference. So there is a difference. The difference, if any, if there lies any difference due to the time constraint or something else, or any due to any updation of rules or legal formalities, etc., then there may we may get some difference in fees there. So the difference, if any, in the scale of fees between the fees charged from a natural person and the fees chargeable from another person, that is other than the natural person, in the same matter, this shall be paid by the new applicant. Okay, the difference shall be paid by the new applicant along with the request for transfer. Fine. Next one is 3A. Okay, so that means 3 is not yet completed. This is subrule 3A. In case an application processed by a small entity is fully or partly transferred to a person other than a natural person except a small entity, the difference, if any, in the scale of fee or fees between the fee or fees charged from a small entity and the fee or fees chargeable from the person other than a natural person except a small entity in the same matter shall be paid by the new applicant with the request for transfer. Okay, so just take a look at the subrule 3. Here we have that, what is the bold letter here? Application by a natural person here. Fine. And here what happened? Application by a small entity. So just we are in that subrule we were considering a natural person, and here we are considering a small entity. Okay, so the difference is between a small entity and a person other than a natural person. Fine. And there, that was the difference between a natural person and a person other than the natural person. Fine. Here, a small entity with a person other than the natural person except a small entity. So this difference shall be paid by the new applicant with the request for transfer. Rest things are same. Next one is 3b. In case an application processed by a startup is fully or partly transferred to any person other than a natural person or a startup, the difference, if any, in the scale of fees between the fees charged from a startup and such person to whom the application is transferred shall be paid by the new applicant along with the request for transfer. Here also, friends, in sub-rule 3, we have discussed about natural person, that is replaced as small entity in 3b sub-rule, and here, in 3a sub-rule, that natural person of 3 was replaced by small entity, and in 3b sub-rule 3b, that small entity of 3a is replaced by a startup, nothing else. This is the simple difference. Okay, so the difference will be calculated between the startup and the person other than the natural person or startup. Fine. And what is the explanation? Where the startup ceases to be a startup after having filed an application for a patent due to lapse of more than 5 years from the date of its incorporation or registration, or the turnover subsequently crosses the financial threshold limit as defined, no such difference in the scale of fees shall be payable. Okay. If everything is in normal condition, then that difference would be payable. But if the startup loses its what we can say, loses its name, that means it ceases to a startup, it ceases to be called as a startup due to the lapse of time, appropriate time, or due to the turnover which exceeds the financial threshold limit. Due to those reasons, it will not be called a startup. So in that situation, there shall be no difference in the scale of fees, and that means we can say here no such difference in the scale of fees shall be payable. Fine. Next one is sub-rule 4. Fees once paid in respect of any proceeding shall not ordinarily be refunded irrespective of whether the proceeding has taken place or not. Fine. That means once paid shall not be refunded irrespective of the proceeding, whether the proceeding has been taken or not taken, but the fee will not be refunded, provided that if the controller is satisfied that during the online filing process the fee was paid more than once for the same proceeding, the excess fee shall be refunded. Normally it is not refunded in normal cases, but if the controller finds that due to some online process mistakes or due to some online failures, or we can say some link failure, or due to some problems due to some problems, the fee was paid more than once, then that excess fee will be refunded. But the condition is that the controller should be satisfied. Fine. Next one is sub-rule 4a. Notwithstanding anything contained in sub-rule 4, upon the withdrawal of an application in respect of which a request for examination has been filed, but before issuance of first statement of objection, the fee may be refunded to the extent prescribed in the first schedule on a request made by the applicant in form 29. Just a condition is written here, friends. That means notwithstanding anything contained in sub-rule 4. That means sub-rule 4 will work on its own way, and here upon the withdrawal of an application in respect of which a request for examination has been filed, but before issuance of first statement of objection, the fee may be refunded. That means request for examination is filed, but first statement of objection has not been issued. In this time, the fee may be refunded to the extent prescribed in the first schedule and in form 29. And what is form 29? The title is request for withdrawal of the application for patent. Next one, 5 sub-rule 5 1. Sub rule 5 clause 1. Subject to the approval of the controller, any person may deposit money in advance and request the controller to realize any fee payable by him from the said deposit, and in such case the date of the receipt of the request to realize the fee or the date on which the request to realize the fee is deemed to have been received, whichever is earlier, shall be taken as the date of payment of the fee. So just take a look here. The keywords are approval of the controller. Any person under the approval of the controller, any person may deposit money. He or she may deposit money in advance. Okay, and he or she can request the controller to realize and if any fee is payable by him from that deposit only. And in such case, the date of receipt of the request to realize the fee or the date on which the request to realize the fee is deemed to have been received, whichever is earlier, this shall be taken as the date of payment of the fee. Okay, fine. Provided that the requisite amount of money is available at the credit of the person making such request. Provided the condition is that, or provided that the requisite amount of money is available at the credit of the person making such request. Whoever is making such request, amount will be credited to his account. Number 2, subclause, or we can say clause 2. Subject to the approval of the controller, any person may discontinue the deposit of money in advance, and in such case the balance, if any, shall be refunded. Fine. So in some cases what happens, under the approval of the controller, any person may discontinue the deposit of money in advance. Okay, and here if there is any balance, it shall be refunded. Okay, so friends, rule 7 is completed. If you have any questions, any queries, so please write down in my comment box. And yeah, thank you all. Please like, share and subscribe. Please interact, friends. Please interact. If you have any questions regarding the rules, acts, anything else, you can please share in my comment box. Thank you so much. In the next video, I will continue with rule 8. Thank you all. Stay safe, stay blessed. God bless you. Jai Hind.